Good morning.
Morning.
Morning, John.
Morning, Judge.
Morning, Judge.
So before we get started, I have two matters on the calendar today. One of them is a TRO in the matter of, hoping I'm going to say this right, me and my versus Rooks et al. Who do I have here on that matter?
Andre Hendrick on behalf of the plaintiff.
Okay. And do I have anyone here on behalf of any of the defendants? I know I think a couple of them have been served, but not all of them. So, Mr. Hendrick, just so you know, well, number one, I think my staff attorney warned you. I have a pre-scheduled pretrial conference with all these lawyers this morning. And so I would suggest that if you would come back at about 10 o'clock, that would be a much more likely time for me to meet with you. Number one. Number two, to the extent that no one else shows up, we'll deal with that if that occurs. But in the interim, I'm sure Mr. Freehoff communicated with you, but that what I'll be looking for is you to, make a record of any information you have about the efforts that you made to notify the other parties, even short of service, but to give them notice of today's proceeding, just so you'll know that I'll be asking for that to be on the record. Okay?
Yes, Your Honor.
You're free to just mute and turn off your screen. You're also free to just log off and log back into this video Zoom at 10 o'clock. Okay?
Okay. Thank you, Your
Thank
Honor.
you. And again, I just saw a couple of other people join. If anyone is here for the me and my versus Asia Rooks et al., you're free to log off or mute and remain quiet and turn off your video until 10. Because I'm not going to get to that matter until 10. Okay. So first question to the parties in the Ironside case. Is there a court reporter that I need to be cluing in for takedown?
Not by
No,
10
no, Your Honor.
Okay. So then my second question is it the party's expectation that, well, I'm sorry. My second question is to figure out who all the parties still are that are still standing. So in the Ironside versus Thrive, it appears to make my understanding, based on an announcement by email that I received from Mr. Reading, is that Thrive has resolved their case with Ironside Homeowners Association, and that leaves only BFS. Is that correct?
Yes, Your Honor, that's correct.
Okay. And in the Ironside versus Ironside East Atlanta, Ironside Homeowners Association has resolved its claims with Ironside East Atlanta, and that leaves, and Structurally Sound. And there was one other entity. Was it Drain Right Gutters that was dismissed voluntarily? I can't remember. I'm having a hard time keeping track of all the parties, Mr. Reading.
Uh, Earthly Matters Contracting was the
Earthly
party that
Matters.
was
Thank
recently
you.
dismissed.
And so that
We
leaves Atlanta Metal Works, Chandler Exteriors, Correct House Wrap, Drain Right Gutters, Exterior Traditions, and Waterproof Decking. Is that right?
that's correct, and we are in the process of finalizing settlement paperwork with Atlanta Metal Works, and
Okay.
as of yesterday, with Drain Right Gutters and Roofing and uh, Waterproof Decking.
Okay.
So that would
And
leave Correct House Wrap, um, Chandler Exteriors, and Exterior Traditions.
but that removes Drain Right Gutters. I know Structurally Sound is already out and it removes Waterproof Decking, correct?
Correct.
Okay.
Yes, Your Honor.
So then my third question, I guess, out of my many questions that I have is these cases have not technically been consolidated for discovery. They've not been consolidated for any purpose that I'm aware of. Is there some reason that we are not going to try the sole defendant BFS, that case, together with this one? And mainly I ask because the pretrial assessments of how long it would take to try the case is a long time to try two cases back to back. What are our thoughts on that, Mr. Reading?
I think, Your Honor, we're open to the court's suggestions. We filed the motion to consolidate the cases. I think we're certainly open to them being tried together. I think we did not get consent of all the parties to consolidate, which is why we never submitted an order to the court.
Okay. Do I have counsel for BFS here?
You do, Your Honor. Scott Witziger on behalf of BFS.
Thank you, Mr. Witzgerter. And what are your thoughts? Obviously, there's a lot of people that would have to agree to this. It's just in terms of the courts, because there's really two questions. If we're not going to try them together, which one are we going to try first? And what would be the concern about trying them together from your perspective, Mr. Witzgerter?
We didn't oppose the motion to consolidate,
Okay.
which, as you know, isn't a full-throated endorsement of consolidation.
Right.
And to the extent they're not going to be consolidated, however, we don't think we should be the first ones to go out. We were the second filed, obviously, so we think the first filed should be the first one to go out. But again, we didn't oppose the motion to consolidate. To the extent they are going to be consolidated, obviously, we'd rather know that sooner than later, and we'll move forward accordingly.
Okay, thank you very much. Mr. Brown, I know you represent Chandler Exteriors, and I see that Ms. Noland helpfully identified herself as Exterior Traditions Counsel, but I'm not sure I have a clear understanding of who else represents everybody else.
Your Honor, Michael DeLeva, I'm with Mary Margaret Nolan's office, assisting
Okay.
attorney on Exterior Traditions.
Okay. And what about Atlanta Metalworks?
I don't see that their lawyers appeared, Your Honor.
Okay, is that surprising to everyone? It is to me, but y'all may know something I don't know.
Well, I mean, they are one of the parties that we have settled with.
Okay.
I will say that the settlement agreement has not been fully executed yet, and nor have we filed the motion to dismiss them from the case.
Okay. So I'm going to put Atlanta Metalworks as a tentative, not in this case. And then who's representing Correct House Wrap? Ms.
I am
Pettigrew?
Dawn Pettigrew for
Thank you
Correct
for,
House Wrap.
yeah, I see that you updated your label. Thank you so much, Ms. Pettigrew. Okay. So, Mr. Brown, what are your thoughts about trying BFS all together with the remaining Chandler Exterior Correct House Wrap and Exterior Traditions?
No opposition, and in fact, I was going to defer to Scott, and I do defer to Scott, and what I heard is that he's okay either way. So am I.
Okay, thank you, sir. And Ms. Pettigrew, what about Correct House Wrap? What do you think about trying BFS together?
I have no objection, Your Honor.
Okay, and Ms. Nolan or Mr. DeLeva?
You know, I'm not sure that I can consent. The plaintiffs are different, correct? On this, isn't it the HOA and then individual homeowners?
Not to my knowledge. My understanding is that in both cases, I'm looking at the caption of the case ending in 296 and the case ending in 461, and Ironside Homeowners Association, Inc., unless there's some procedural adjustment y'all have made in recent days, which I know there's a lot of moving parts in recent days, that it's the Homeowners Association that is the claimant in both cases, Ms. Noland.
I guess the only thing that I would say is that a lot of the discovery has been, I guess, done at the same time. I don't know that I personally have been copied on some of the things that have been in the other case. So as long as I'm able to confirm that I have everything that's occurred in that case, discovery-wise, that I potentially wouldn't object to that consolidation from that standpoint.
Okay. Mr. Reading, what are your thoughts in terms of the extent of discovery that is coextensive across both cases?
Your Honor, I think the depositions were all noticed together, and the parties all appeared for those depositions, including BFS for the depositions that were noticed in the case ending in 9461. To the extent any interrogatory responses or requests for production of document responses were not served on any other parties in the other case, we can certainly make sure that those are exchanged.
Okay.
Sorry to interrupt, Your Honor, but that's Ms. Nolan and Mr. Regan raise a good point. I don't know that we have all of the pleadings in the other case. The reason we didn't oppose the motion, quite frankly, is that, it would have been an uphill battle, I think, given the situation. But that is a great point. We are going to need all of the pleadings and all of the discovery. And so long as everybody represents that can happen, no problem.
Okay. Thank you, Mr. Witzquirter. And given your position, if something arises that creates a difficulty for you, I'm certainly willing to hear that.
Sure.
But trying one case with a whole bunch of defendants that will be a little bit unwieldy for 6 or 7 or 8 days is better than trying one case for 6 or 7 or 8 days and then turn around and trying basically the same case against one defendant for another 4 or 5 days. And so to the extent that there is no objection, it is the court's intention to combine the cases for trial, subject to any assertion that Mr. Witzgreuter might raise on behalf of BFS. And of course, qualified by the representation that the parties all made, that so much of the issues overlap and that so much of the discovery has been combined or has been conducted in tandem. So obviously, if that is not the case, once everybody gets where we're going, then let me know and we will see if we can readjust.
Your Honor, if I may ask a question.
Yes, Ms. Pettigrew.
Pettigrew, there's no court reporter. I was about to announce myself again. Sorry. I was just
Old
saying,
habits, right?
Cases are consolidated. Would there be an issue as far as apportionment from what used to be a non-party to what would be technically a party now?
Those are all issues that y'all will need to work through in terms of what the verdict form looks like. The only reason I'm suggesting it, and this is, I would have to defer to all of you because you know much more about the substance of your case, but the court's general read of it is that all of this has to do with the alleged water intrusion that has resulted to this property, and that's why the homeowners association has sued the various defendants, and that BFS has a particular role from the plaintiff's perspective. Correct House Wrap has a particular role, exterior traditions, etc. And so obviously that is a factor. But my thought simply was that at trial, there's no way, if BFS was a contractor on this property at a various point, there's no way that in your case, the jury's not going to hear about BFS and the work they did on the property. And I suspect the same is true in a case, even if it was just against BFS alone, there's no way that the jury's not going to hear about the work done by Correct House Wrap or by Exterior Traditions, etc. But I think it's an excellent point that y'all need to work through. And again, I'm not asking you to marry yourselves to it right now. If we get to the first day of trial and the parties tell me that there's some other issue that has arisen, then the parties can expect that we will go out on the 379-461 case because it is the first filed, unless the plaintiffs tell me there's some reason they don't want to go out on that case, and we'll take BFS out of it if there's a reason that we need to. But I feel like there's some time for the lawyers to get together and figure out what it might look like if you tried it all together and how to address issues that might present themselves. And so that's where we're going to leave that for now. Right now, it is the court's intention to consolidate the cases for trial and try them all together. The extent to which the parties want various and different verdict forms or how it affects apportionment issues and other things, those are things that I expect and hope that all of you will work together. And if you can't work them out, we'll bring to my attention and let me know what needs to be resolved. Okay, so mostly what I have on my agenda for today is to sort of talk through the motions that are still pending. As I understand it, really the only motions that are still pending and pending-ish are the drain right gutters and waterproof decking had filed summary judgment motions. I assume, Mr. Reading, based on your announcement, that those motions are obviated now?
Yes, Your Honor, I believe that's correct. Mr. Ludwig may be able to speak to that, but I would imagine those motions are moved or withdrawn.
Thank you, Mr. Reading. Mr. Ludwig?
Yes, Judge, those motions are mute, as well as our motion to extend time to file or extend the time for filing our summary judgments, which kind of goes hand in hand.
Okay, thank you. Okay, and so I think then that only leaves the motions in limine. Am I correct? Or is there one of the 8,000 motions that have been filed in this case that I promise I have been diligently trying to address? Have I overlooked one? Mr. Reading.
Well, Your Honor, I think Mr. Freehoff's email did refer to the motions for summary judgment concerning Thrive. That
Okay, but
Thrive
those are,
file. Again,
yes, I
same.
was diligently working on those orders and I appreciated you letting me know that they had been resolved so I could stop working on those orders. Thank you.
Yes, Your Honor. No,
Um,
apart from the motions and lemonade, that's all that I can think of.
okay.
Your Honor, if I
So
may,
yes, Mr. Kistler.
I did file one motion. We are settled. I did file what's called a clawback motion just to get records related to unrelated projects. So obviously the project is the Ironside project. In the course of discovery, we were ordered to produce certain documents. It included properties in Tennessee, townhomes in Decatur, single family homes that were built in Decatur as well. We produced them obviously, but we would like to claw them back as being unrelated. I filed that motion yesterday because now
Yes,
that our
sir.
settlement's final, I don't know if it's going to be opposed or not. Certainly not expecting anybody to be in a position to respond to it if they're objecting to it, but it solely pertains to the unrelated records.
Okay. Mr. Reading, obviously he just filed it yesterday, so I don't know that anybody's expecting you to have a substantive response. If you do, great. If not, then I guess we will wait the appropriate amount of time for you to have an opportunity to determine if you're going to object to that motion. And then either you can let Mr. Kistler know you don't object, or you can advise the court that you can file an objection and let me know, and then I will sort that matter out between you and Mr. Kistler regarding the Thrive defendants.
Yes, Your Honor, I would appreciate that additional time. I did kind of give a cursory glance at the motions yesterday, but don't know for certain whether we'll oppose those or not. I would be surprised if we did, but still would like additional time to review.
Okay, excellent. Thank you. Okay, so yes, sir.
I do have one question for Mr. Kistler's motion. Is he asking for us just to, remove them from our files and, send them to the shredder? What exactly is he asking? Or is he going to physically return something when you say clawback?
I actually indicated to delete them and to get them back from anybody you might have given them to expert-wise. Candidly, I could care less about that. What I don't want is them going out and being made public in any kind of any other reason. I don't want them going out to either damage the company or whatever. If they are electronic files, would love them to be deleted. If you need to keep them, however, as part of your document preservation purposes, I don't want to put anybody in breach of their document preservation policies, whatever those may be. We just don't want them floating around there. So, for example, I gave them to my expert. I would want to call them back and have them put in my file so that they're not further disseminated. That's really the goal of it, is we just don't want them floating around on the street. They have all kinds of information that's just completely unrelated and for other projects. So.
Okay. And it sounds as if, given that Mr. Kistler just filed it, first, it sounds just on its face as a fairly limited and reasonable request, number one. But number two, y'all have plenty of time to figure out, and presumably will be post-trial by the time you need to figure out what you're doing with those documents. So what that leaves me with is the motions in limine. And so I'm going to try and plow through those. Before I do, I just wanted to give you guys a little bit of, I don't know that any of y'all have tried a case in front of me. So I just wanted to give you a little bit of background. Unless there's any particular reason that the parties think we need more than 36 jurors, you're going to get 36 jurors. You are, we'll figure out the lay of the land in terms of asking questions. One thing I do ask you to do, because I find it goes more quickly, other than asking the preliminary questions, I'm perfectly happy to let you guys try your case and pick your jury and ingratiate yourselves with all these potential jurors. Y'all have fun with that. The only thing I'm going to do is ask just the very general questions about making sure that they don't know, that they're not related to any of y'all, that they're not related to me, which has actually happened. So random things like that. I will just ask those preliminary questions and then I will let you guys ask the questions you want to ask. The only thing I ask that you do, because I find it speeds up the process, is in civil cases, a lot of times people are used to, any of you ever fired somebody? Raise your hand. And then, oh, juror 27, you said you fired somebody. Let's talk about that for a minute. What I found goes much faster is if you simply make notes of those jurors and then at the appropriate time, when it's time to ask questions of juror number one, ask juror number one or juror number 27 about those yes and no questions. So I've just found that it goes a little bit faster. And so that's a little bit of an adjustment for civil attorneys because it's more like what we do on the criminal side. And so we can walk through that and what it looks like, but I just want to give you a heads up on that one. Number one. Number two, if you are going to, for evidence presentation purposes, so we use Zoom rooms, right? Which means that every day of trial, you will get a Zoom link and you can log into that Zoom link. There is a giant board that faces the jury. I have a computer screen on my desk. The witness has a computer screen, and there are computer monitors on the podium and on each of counsel's table. Now, I only have that one on the defense side, so you're going to have to figure out how to share, but obviously you'll have laptops, and so you can see everything that's being demonstrated in that way as well. The reason I mention all of that is a couple of things that are important. I don't know if there's any audio or video evidence in this case, but if there is, you'll need to turn on the share sound function in Zoom and then keep yourself muted. I know it sounds wrong, that it is counterintuitive, but that is how it works. And I promise it will work. Number one. Number two, it is possible, but not practical to have a witness authenticate a document electronically. As in, I'm going to show you this document, but not anybody else. And so I'd suggest to you that even though you're planning to do this almost entirely electronically, that if you need a witness to authenticate a document or to lay an appropriate foundation for that document before you're offering it into evidence, I would suggest to you that you need to go ahead and have paper documents to show that witness before it actually gets into evidence. And then once it's in evidence, you can publish it and share your screen on the big boards and it'll be on everybody's screen and everybody can look at it. Also, if you want to familiarize yourself with that process, Mr. Freehoff is happy to arrange a time when we're not using our courtroom. And I will tell you, I have to be at a conference next week. So my courtroom's pretty much empty, especially the first part of the week. So if y'all wanted to come, he could set up a Zoom room for you and you could just make sure that you're familiar with how it works, if you choose to do so. You don't feel obligated, but just want to let you know that that's an option for you. Any other questions in terms of how the process of jury selection and that sort of thing will go? Nope. Okay. So let's move into the motions in limine. I have the same four motions in limine were filed by Ironside Homeowners Association in both cases. I'm going to go through those now. They seemed fairly straightforward, with a few exceptions. I think the first two seemed fairly straightforward. The last two might require a little more effort. Regarding the matter of insurance, I would assume that there are probably 27 overlapping insurance policies that are at issue, and that all of your fine clients are being represented by their respective, being provided counsel by their respective insurance companies. What is everyone's position? I'm going to start with the defendants. Do you have an objection to the motion in limine filed by Ironside Homeowners Association regarding insurance? And I realize I'm looking at number two instead of number one, but start with Mr. Brown.
No objections.
Okay. Ms. Pettigrew?
Reviewing it now. No objections, I believe, Your Honor.
Okay. Ms. Nolan?
And no objections.
Mr. Witzberger?
Objections, Your Honor, so long as it applies across the board to potential insurance for defendants as well.
Yes, and to that end, I would actually need the lawyers to do me a favor. The Court of Appeals has expressed a preference for written orders on motions in limine. And so if you guys could please email me in Word, or Mr. Freehoff, in Word format, the motions in limine that you have filed, I will convert that into a working order, for a couple of reasons. One, the Court of Appeals has expressed a preference for it. Number two, it provides everybody with a clear, hey, what was the judge's ruling on this? And to Mr. Witziger's point, and I feel like I say your name different every time I say it. Can you say it again for me one more time?
Witziger, Your Honor.
Witziger.
If you take that second E out, it's pretty phonetic.
Okay, thank you, sir. I appreciate that.
That
So,
first E, sorry.
and to Mr. Witziger's point, I will tell you that unless there's some particularly unique issue about a motion in limine, I'm very much a what's sauce for the goose is sauce for the gander. And if I enter a motion in limine, it will not say the defendants may not do, it will say the parties may not do whatever. And so in this case, for example, to Mr. Witziger's point, it will say the parties may not discuss issues related to insurance. Now, that always begs the question, if we're all in agreement on that issue, what about qualifying the jury? Because there's an argument to be made. I know it's fairly standard to do so, but in my way of thinking, there's an argument to be made that if insurance is never going to be mentioned, then why do we need to know if someone is associated with an insurance company, since they won't know that there's insurance? But of course, it could be that they do know because they work there and they were the claims adjuster. Who knows? What are our thoughts, Mr. Reading?
Your Honor, in terms of whether we need to qualify all jurors as to all the insurance parties that are involved.
Yes, sir.
I mean, I don't know that we have a specific stance on whether that needs to be included if it creates an issue
I'm
potentially for
jumping
appeal,
ahead.
then we would prefer
Forgive me for interrupting, but I'm jumping ahead because it was brought up, I think, in the motions in limine filed by maybe correct House Rep. And so I'm jumping ahead a little bit, but.
Your Honor, Chris, may I? Yeah. Sorry, Your Honor. Rich Capriola, I'll be trying the case with Chris.
Yes.
Yeah, I guess our preference would be that they are qualified exactly for the reason that you said. You know, to the extent that folks work at an insurance company and have knowledge of a claim, I'd certainly like to know if they do. You could also approach that possibly as anyone aware of this case, you know, prior to coming in the courtroom. That type of an approach might be acceptable as well, but some way to get at that issue.
Okay. And we might do that. For now, I'm going to note that the motion in limine number 2 regarding the introduction or discussion of insurance is going to be granted. And the parties are not going to discuss the existence of insurance, and we'll deal with the voir dire issue when we get to it in the other motion. But I think as a preliminary matter, I like the approach you're suggesting, Mr. Capriola. Okay, now going back to number 1, the settlement with other parties. Mr. Reading, tell me the broad strokes outline of what you are concerned about, because obviously the existence of these other parties and the potential role they played in creating the negligent construction or the nuisance or hazardous condition that exists is relevant, and I expect I'll hear a lot about it. Is your concern simply that those parties have already paid and gotten out of the case because of the concerning implication that they acknowledged they were at fault?
Yes, Ron, that's the primary concern. The motion also addresses, for the purposes of apportioning not fault but damages to those parties, that not be included as part of the verdict form for the jurors. Also, that takes into account whether proper notices to non-parties or notice of non-party fault was provided as it relates to the two cases.
Okay. So starting with the first issue, let's start with the first issue in terms of who. So I guess we'll start. I'm just going to go in order each time. I'm going to start with Mr. Brown. In terms of the first part of that, which is the argument, you know, whether or not they want to prohibit any mention in front of the jury of settlement by these other parties, separate and apart from evidence regarding the role they played in the construction of this project. What are your thoughts on that, Mr. Brown?
Uh, Your Honor, I am opposed to that as stated broadly. Obviously, we can't get into the details of any settlement, but they were parties in the case. They're no longer parties in the case. I believe that we're entitled to say that that they resolved their claims, but and there's a blending between the two, Your Honor. So I'm not sure how to keep them separate. That they were a party, they resolved, but here's the role that they played in the case.
Well, and
for the purposes of apportionment.
okay. And that's so the reason I started the way I started is I think that the role that those individuals played in the case, and if noticed properly, the argument that those parties should be apportioned is a separate issue from the issue of they settled. Let's all think about whether I'm going to argue it affirmatively or not, what that means. And so what I was attempting to separate is, it seems pretty straightforward to me that certainly I have instructed jurors that those parties are no longer in the case. Oftentimes that is accompanied by those parties are no longer in the case, and you shouldn't concern yourselves with how or why that is that they're no longer in the case. But I didn't grant summary judgment or other relief to those individuals. And so that, to my mind, would mean that the matter of their liability is still an open question for purposes of presenting the case. Now, apportionment carries with it some procedural requirements that Mr. Reading was mentioning, and I don't know the extent to which those have been done, but the existence of those entities and their role in the construction of this project, I don't think there's any basis that to prohibit the parties from talking about that. But the fact of their settlement is a different matter entirely, and that's what I was trying to key in on. Does anybody object to the effort by the plaintiff to prohibit the parties from saying, hey, jury, structurally sound, settled out of this case?
Your Honor, the way that you describe what your instructions would be, I'm on board with that. I think that strikes the appropriate balance.
Ms. Pettigrew?
Your Honor, I agree with that to the extent, again, to the extent the parties can make sure we can emphasize you sued these parties or hear other notices that you provided of defects that these parties committed, so that their liability isn't somehow lessened by their removal in the case and we're precluded from making those arguments supporting our apportionment. But I do agree that, the exact terms of settlement or any amounts should not be brought into the case.
Ms. Nolan?
Your Honor, I think one thing that sticks out in my mind is that we don't have access to any of what those settlement agreements say or the terms. So from the standpoint of there are many different types of settlement. There are issue releases, there's full releases, and to some extent, the landscape of this case has massively changed over the past a week and a half, because at the beginning of, or as late as yesterday, there are more people in this. So how the plaintiff is planning on presenting this case, are they just presenting this case as to my client and my specific amounts, or are we still going to this at I don't know if any issues have been released within those settlement agreements. And I think that's really important for the parties on this side to know. It's hard to say, oh, we can't talk about settlement agreements when we don't know what's even in those. So that's one thing that I would think about, your framework that you referenced, as long as I'm not saying that I don't think that if there have been no issue releases and the whole case is being presented as against these last three parties as a whole, But I'm allowed to apportion to everybody who's been in the case, despite their settlement, then I don't see a problem with your framework, but I also don't know what's actually been released. And if there are issues that are not going to be presented at trial, as a whole, as against my client. There's also another issue that's kind of out there that is important for this, and that's that the Thrive and Ironside East Atlanta have tenders out there that are not being presented. So it's also very important as far as allocation that we have access to a full allocation of everybody who's been in the case.
Okay. I don't know that I don't know that I have some of the particular facts of which you are speaking. And I do think that the specific issue of apportionment, even is different from the idea that the parties can talk about Thrive was in charge of this or Chandler Exteriors was in, just as any of y'all might say the other guy in the other chair was in charge of this. I fully expect that you'll say that the guys that should have been in those empty chairs over there are responsible for this. That's different than apportionment, which Mr. Reading has at least asserted may or may not have been procedurally preserved or noticed. I don't know. But I'm just trying to get a lay of the land. I don't know about the tender issues that you've asserted, Ms. Nolan, and I assume I'll need to be educated about that if it's something that I need to deal with. But for now, Mr. Witziger, what are your thoughts, sir, on this broader issue about settlement versus, evidence, argument, et cetera, regarding the role that those entities played in the case?
Your Honor, appreciate it. Just to piggyback on what Ms. Nolan was saying, and before I say this, I'm not trying to impugn anybody or suggest that there's anything untoward. But before this hearing started, I wasn't even sure who all the parties to this trial was going to be, who all settled for anybody. Speaking to the broader issue, it does change the landscape. How are we going to get certain witnesses for people we expected to be at trial who are now not going to be at trial? Are they going to be made available to us, so on and so forth? So I'm just giving you a heads up, Judge, that those could be issues a week from Monday when we start this case. I'm hoping it won't, and I'm not suggesting it will be, nor am I suggesting anybody's done anything wrong. Just want to get that out right now. With respect to settlement, just to give you a little bit better lay, and you probably know this, Ironside Homeowners Association, Inc. is the homeowners association for this condo association. The biggest problem I have is that Thrive is now out of this case. Thrive was the general contractor. Thrive was in contractual privity, I would think, with most, if not all, of the parties who are going to be remaining. They were the general. Various subcontractors and vendors remain, of which my client is one. So the big problem I have now, without seeing the settlement, isn't so much from a liability standpoint to use that settlement to say that, oh, they've admitted they were at fault, because I'm going to assume that the settlement, like every other one I've ever seen, there's no admission of fault by anybody in there. It would be more of a damages issue. Thrive, as the general contractor, was responsible for not ostensibly, but for practically all of the damages that have been assessed in this particular case. And to the extent that any of the settlement proceeds that Thrive has submitted went to satisfy some of the damages that they're now claiming against some of the other defendants, we run the risk of double recovery. Again, I wish I could tell you, Judge, how I knew how we should handle that. But my client supplied doors and windows here. I doubt that the settlement specifically states that, X amount of the proceeds are for the doors and windows. But it is more than reasonable to conclude that some of the settlement proceeds went for that. Again, I understand we can't say they settled, therefore they admitted they were liable, but it is a huge damages quagmire at this point, just given that posture. And again, I don't know how we're going to redress that without having seen the settlements, but assuming what's in them, it makes it difficult to speak intelligently on the issue in this hearing.
And yet you have, Mr. Witziger.
Ma'am?
Yes, sir, Mr. I said, and yet you have, Mr. Witziger, spoken intelligently about the issue. Mr. Brown, yes.
Yes, Your Honor. to me, there's a significant issue, and I spoke some with Chris about this just a couple of days ago, and Chris has been good to work with, and of course, you know, I've known Rich for. I'm not going to tell on us, Rich, but I want to put this in the context of what Scott just said and what Mary Margaret just said, which I was thinking about. And I don't know the answer to all these questions, and I sort of apologize that I don't know the answer to all of them yet. But I got a lot of new information this morning.
Sure.
So if someone's saying that something procedurally has not taken place with regards to any procedural issues with apportionment, well, no one knew that some of these parties were not going to be at trial until 15 minutes ago. So I don't know how that works out. And Your Honor made a good point between the difference of, well, there's that empty chair there, as opposed to any procedural items that apply to apportionment.
Right.
So I just wanted to raise that. I don't want to wait until the last day to raise that. And then Scott made a good point, which I was thinking about earlier. So Mary Margaret and Scott said things that I was thinking about. And that is, we all had our specific little world of people that we wanted, that we were going to make sure that are at trial, and counting on other people to make sure that certain other folks that are at trial. Well, that landscape has changed too. And some of those folks, we got to make sure that they're at trial, or we're going to just be doing a whole lot of reading of deposition transcripts, which.
Oh, and we don't want to bore the jury to tears doing that if we can avoid it, please.
That would bore me to tears. So again, I spoke with Chris about this yesterday, and I think it is now something more that we need to sort of think about, and that is, I think that we need to make sure that we have time to line up all of those additional witnesses.
Okay.
And again, I hate to do that, but it's better to peel that bandage off now.
So so let me back up a little bit. One, we are still 10 days out from jury selection, and probably 11 days out from the first witness being called. And I trust that you, quite capable, quite experienced attorneys who all understand that when there's 47 defendants, that people start settling left and right, and then you might get to trial with one person who's like the 87th down subcontractor who doesn't know anything about anything. But I trust that you parties can figure that out, and to the extent that it changes the lay of the land, bring those issues to my attention. For now, it sounds as if everybody agrees generally, because that is generally what the law says, that the fact that other parties have settled their cases is not relevant information to present to a jury. Now, as I said, what I have typically done is advise the jury to the extent it's necessary and becomes appropriate. As I mentioned, Mr. Brown, something along the lines of, there are other parties that you're going to hear their names, and those parties are no longer, or not in this case, or no longer in this case, depending on how I frame it. And you're not to concern yourselves with how or why they're no longer in the case. That is, in terms of the most basic aspect of Ironside's motion in limine, it's going to be granted to that extent, because we all understand that that's generally what the law says. Now, to Ms. Nolan and Mr. Witzegruder and Mr. Brown's point about what the substance of those settlement agreements might have to do with the larger issue of damages, etc. You guys are going to need to figure that out in the next week or so, and then let me know, rather than speculating about what might be the case, right? Let me know what you observe as particular issues. For now, I do agree with you generally, Mr. Brown, that to the extent there's any argument being made that notices of apportionment of non-parties were not timely filed, when in fact they wouldn't have had to be, because those parties were parties. Those non-parties were parties until recently. And I will say that at least currently, everybody except, I think there's only two entities in the 461 case that have actually formally been dismissed, or a notice of settlement has been filed. Everybody else is still technically a party to this case. And so I think that the larger issue you guys will need to deal with is figuring out what the substance of those settlement agreements might have, how it might affect you. But the basic premise of the motion in limine, I think, is granted, in the sense that we're not going to talk to the jury about that these other parties settled out. But again, to be clear, that doesn't limit the parties from talking about the fact that they had, what their role was in building this building, or in allegedly causing the negligent conditions that are asserted. So the third item that was raised by Ironside Homeowners Association was the purchase and sale agreements. And obviously we've dealt with those a lot, because I've dealt with the arbitration clause, and then I dealt with the exclusive remedy clause, etc. The only question I have, Mr. Reading, to the plaintiffs about this motion in limine is that I admittedly don't have the laundry list of all of the individual owners, but my recollection is that there was a distinction between, there are some owners who are the original owners who were subject to that PSA, who that's how they came to own the property, understanding that this suit is being brought by the homeowners association. But my question is, to your way of thinking, is there a distinction between the relevance of a PSA to, say, an individual homeowner who is the original homeowner, the original purchaser, versus one who is not? Mr. Reading?
No, Your Honor, I don't think there's any distinction. I mean, what we're trying to limit, as the court's aware, obviously, a lot of the motions practice addressed the substance of what was included in those original contracts. So what we're trying to have excluded is those contracts, to the extent they're pointed to show what, the existence of the arbitration clause, the existence of the warranty as an exclusive remedy clause. As the court has determined, those clauses are not enforceable against the association. They're not going to be relevant. We're seeking damages to what the association maintains, controls, and has the duty to repair. And that's the evidence we intend to present. Obviously, the unit owners will testify in this case concerning the damage in the interior of their units that is coming from the exteriors. But as far as the substance of those contracts, we think those should be excluded and kept from the jury. But we're specifically speaking to those original contracts.
Okay. I'm going to start with Mr. Brown, unless one of the other defendants, I don't know if you guys have divided and conquered at any point, but I'm just going in order of how everybody's listed at this point. But Mr. Brown, given the court's prior rulings about the arbitration clause not being enforceable against Ironside Homeowners Association, and et cetera, and given the fact that the party to the purchase and sale agreement is no longer a party, presumably, what relevance would those documents have, or are you not going to object to this motion in limine?
Your Honor, I object in part. I agree with Mr. Reading that those two main terms in the contract, which the court has ruled upon, that should be limited. In other words, I would not speak with any witness or any juror as to those. But I think that it lays a foundation, those documents lay a foundation that this is the person who actually lived there. They bought it, they live there, so they are the best person to speak about the experience there. And here's what I'm getting to. And I actually met with my managing partner on this yesterday. There's an issue in this case, which we are all familiar with. Rich and I have dealt with this many, many times, Scott also, as to extrapolation. And that's something that we've been dealing with in the case. Several of the homeowners testified that they are either not experiencing any water intrusion or that at some period of time they did and they no longer do. So those documents are part of the foundation that these are owners, so you're hearing from the horse's mouth as to what they are or are not experiencing. So from that general standpoint, not getting into any of those other two provisions, the PSAs established that that's who they are, and gives them the credibility for that testimony. And then we get to the issue of whether or not there is enough units that were examined to say that, okay, this applies to this unit when we have this person testifying that they are not experiencing any water intrusion.
Okay. Anybody else want to be heard on that issue regarding the purchase and sale agreements?
Your Honor, I would just say that it's important to have the purchase and sale agreements just to show what the homeowners association owns as opposed to and manages as opposed to what belongs to the homeowners. So I just think as a document, and if the association is bringing this claim on behalf of, their specific portion, that the purchase and sale agreement actually may be relevant to that item as well. So I don't think that can be excluded as part of the basis of where these claims came from.
Okay. Anybody else?
Your Honor,
Yes,
I
Ms.
would agree.
Pettigrew?
I would agree, even though there were defense motions trying to enforce arbitration and warranty clauses, the plaintiff didn't move affirmatively to exclude, as a matter of law, that the ownership issue of who owns what and where, as the homeowners association has argued, well, look, we're only here for the outside areas, nothing to the interior, but we're going to have the actual people who own the interior testify about damages that aren't a part of this case. And then we can't have the documents to establish what they own versus what the homeowners association owns as a blanket ruling. I don't think that would be, I think that would be tying the defendant's hands in advance.
Okay. Anybody else? Mr. Reading, any response to that, sir?
Yeah, I just want to address a couple of those points. First, to the extent I said damage as opposed to evidence of water intrusion, I meant to refer to evidence of water intrusion, not specifically the amount of damages to the interior of the unit, which are not the focus of this lawsuit or damages the association is seeking to recover. It seems to address this issue regarding what the association's responsibilities are. That's spelled out in the declaration. That's not spelled out in the unit owners' contracts. And I haven't really heard a very persuasive argument for why those contracts are relevant. I think someone can come in and testify to what they own without needing to, the defense needing to introduce the purchase and sale agreement, especially when not all of the unit owners that are going to testify in this case are party to one of those agreements. They would have purchased separately pursuant to an agreement from either the owner that bought from Ironside East Atlanta or a successive owner that bought from an original unit owner. So I don't know how, and again, this is a balancing issue for the court. What's the probative value of those contracts? It seems that in light of the potential prejudicial effects of the jurors seeing those exclusive remedy or arbitration provisions, which, they may consider as potentially covering some of the damage that is going to be asserted by the association in this case and for which they're seeking to recover.
Okay. So I'm sorry, Ms. Pettigrew, did you want to say something?
No, just argue if the plaintiff is going to call certain unit owners that had interior damage, but we've deposed others who may have had issues that have been resolved under other warranty provisions, then establishing that, hey, they brought a claim under their contract and they had a warranty claim, things got fixed. Therefore, for Mr. Brown's extrapolation argument that, hey, plaintiff is saying because this happened on one building or one unit, it needs to happen across the board. Being able to establish who owns what and where to say, I think that's pretty much relevant.
Okay. So here's my concern. So let me start with basics. I don't think that the existence of the purchase and sale agreement is that its introduction into evidence is necessary to prove who that someone owned the property or that someone purchased a particular unit. However, it might become relevant if in fact there is to particular units. If in fact there is an issue associated with whether a unit owner exercised a warranty remedy, and if the parties can point me specifically, I hear general statements, but point me specifically to information in a purchase and sale agreement that provides context and information about what is owned and what is not that cannot be obtained from the declaration or other homeowners association documents, which is a long way of saying this. I'm not going to grant a blanket motion in limine prohibiting the offering of the purchase and sale agreements into evidence. But I don't know, Mr. Reading, that I would call it prejudice. I think I would probably be concerned, though, about confusion of the issues, right? That there is not a warranty issue in front of this jury. There is not an exclusive remedy issue in front of this jury. There is not an arbitration issue in front of this jury, because I've already dealt with those issues. Now, to Ms. Pettigrew's point, though, to the extent, for example, there is one or two or three unit owners who had a problem inside their unit, exercise their warranty remedies that are in their purchase and sale agreement, that might be relevant. And the fact that that remedy is in their PSA, that's going to be a game time call. But generally speaking, I am not going to I'm going to deny the motion in limine to keep out all the purchase and sale agreements. However, to the extent that somebody wishes to offer one, they're going to need to have a specific articulable basis for why they believe it's necessary. And I mean each individual one, not all of them writ large. I mean, if you want to ask a particular owner about their PSA, tell me why it's necessary. And even then, because of my concern about confusion of the issues, I might suggest to you that we might consider redaction on issues where I have specifically ruled that the arbitration clause is not relevant or that the exclusive remedy clause is not relevant. So that's how we're going to deal with that issue. So generally for now, the PSA agreement motion in limine is denied in that I am not going to keep out all of them. So the door is open for individual defendants or, for individual PSAs to be offered if they're specifically relevant to a particular issue. But I would suggest to you that I would likely expect some redaction if that's the case. Is everybody clear on what that ruling is going to be generally?
Yes, Your Honor.
Okay.
I think it's
yes,
a
sir.
good balance. Thank you.
Thank you. And then the acceptance doctrine. Please tell me that's totally gone away and I don't have to deal with it anymore because the two defendants that raised it are gone.
That would be our position, Your Honor.
I think that all of us have affirmative defenses in our pleadings, and I believe I raised acceptance doctrine, although I didn't file a motion for summary judgment on it. So I would say it's still on the table to the extent it's presented at trial.
Okay. So I will say that in the context of the summary judgment motion, number one, I think I had already shared with the group that it had been my intention to deny them because they were untimely. I know there was a motion asking us to accept it out of time. Ultimately, I will tell you, when this happens, because it happens fairly frequently, I typically just deny them because they're untimely, but it's because really what would happen is, one, if it has merit, I would expect that the plaintiff would not want us to be bored to tears by evidence presentation about a defendant who has a merit-based defense that would get them out of the case on a DV, which is what we all know would happen. Even if I don't deal with the summary judgment motion at the close of evidence, that defendant's going to raise a DV and probably get out, and now we've all just wasted our time talking about that issue. I don't know if that applies to the issue of acceptance, but I will state, separate and apart from the arguments made in the motion in limine about whether it has been asserted as a defense, whether there's been notice made, the issue of acceptance and whether, in the context of that summary judgment motion, whether these were hidden defects, whether these were inspected, the nature of the inspection, those are all factual issues that would need to be resolved by a trier of fact. I think the only other issue Mr. Reading presented in his motion in limine was this issue associated with whether or not proper notice had been made. Now, I believe the argument in your motion in limine was as to drain right and waterproof decking, not necessarily as to exterior traditions or other parties. And it may be that y'all at this point need to work back through that issue. But certainly it would seem to me that whether those alleged defects that have caused the alleged water intrusion were observable, those are all factual issues that I would expect we would be discussing at trial for any number of reasons. What say you, Mr. Reading?
In terms of the scope of the motion, and I'm trying to review exterior traditions answer, and I did review it before filing the motion. I did not see that this issue had been raised by exterior traditions prior to, nor had it been raised by drain right or waterproof decking before it was asserted as a grounds for summary judgment. So that's the scope of our motions. This is not an issue that was raised by the parties prior to really drain right raising that issue on summary judgment, and now it's obviously been carried over into several of the defendant's portions of the pretrial orders that they've submitted.
Right. I'm going to let y'all duke that out for now, in terms of deciding whether we're satisfied that it was asserted by at least one defendant, which Ms. Noland is asserting exterior traditions did assert, to the extent that everyone is satisfied that it was raised. It does seem as if that would be a matter of, let me say this, as a general proposition from an evidentiary perspective and from a story of the case, I would certainly expect that there would be evidence in this case that would be presented to the jury about the nature of the work completion done by these individual contractors, and that work was accepted by the contractor, or that work was accepted by the actual owner. Now, whether that satisfies the criteria for the acceptance doctrine, I think is something that we're going to have to figure out later. But as an initial matter, I don't know that I can rule on it right now, because there's still an open question as to whether we're all in agreement that it was raised. But assuming that it was, Ms. Noland, I fully accept your representation. It does seem like those are factual issues, whatever effect it has from a legal perspective, whether it's a DV or whether it is straight argument to the jury, we'll have to work through that. But the evidence of the work being done and inspected and accepted, I fully expect that type of evidence is going to come into a construction defect case like this one.
I had to look back. It's my 12th and 20th defense in my original answer. So it is in there. So I think that'll be a bridge that we have to cross it at DV. So.
Okay. So that's going to be my ruling for now, is that the acceptance doctrine motion in limine filed by the Homeowners Association is going to be denied. Based on what the prior statements that I made regarding my expectation that facts about that are already going to be in the record, and Ms. Nolan's representation that at least Exterior Traditions did assert it as an affirmative defense. Although I will say, I did not. I did some quick research, and I note that you've not cited any cases that I did not find. I mean, we can talk about notice issue, but I didn't find any case law that said the acceptance doctrine is an affirmative defense that must be raised in an answer or it's waived. It sounds like it's not. We don't need to know the answer to that because at least Exterior Traditions did raise it. But there's that. So I think that puts to bed the motions in limine that were filed by Ironsides. There are a lot of ones that are filed by Correct House Rep. And no offense, Ms. Pettigrew, because I understand the instinct by lawyers to put it all down because if you don't say it, it didn't happen. But some of these very much are, please apply the rules of evidence. Please apply the law, and I promise I will. But some of them I think are more targeted, and we definitely need to talk about them. Starting with the first one, which is essentially, I think, a Daubert motion dressed up as a motion in limine regarding alleged speculative opinions of the plaintiff's expert, Mr. Lesso. Given that I've had a chance to read your motion, Ms. Pettigrew, I'm going to ask Mr. Reading to respond, and then I'll let you have a chance to respond as well, okay?
All right. Yes, thank you, Your Honor.
Mr. Reading, what are your thoughts, sir?
I'm
Just
not
one
sure.
quick
Rich, you
comment,
want-
Chris, and then you could argue it to the extent we are. But these were served Wednesday evening when the court had a deadline of a week before that Monday. So we really have not had a chance to digest these motions.
Okay.
And to the extent that we're getting a motion, a Daubert motion on 24, 36 hours notice, we would like the opportunity to thoroughly evaluate at least that one issue before arguing it here today.
Okay.
That's our concern.
Okay. So given the breadth and extent of the motions that were filed, I mean, the reason I mentioned some of the please apply the law, Judge, like, for example, number 9, the motion excluding surprise documents and witnesses. So I can assure you, if somebody calls somebody that nobody's ever heard of or wants to introduce a document that nobody's ever produced and somebody shows me where it was requested or where it would have been responsive to a request, I'm not letting it in. But that again falls under the category to me of please apply the rules of evidence and the rules of civil procedure, which I promise I will do.
And Your Honor, if I may, I did note that some of these are just pretty much a given. I did have a pretrial hearing yesterday where I had to argue each and every one of these because the attorney on the other side wanted to challenge it. But I would just say 1, 13, 22, and 23 kind of relate to specific issues to this case. 16, 19, and 21 are just more kind of procedural inquiries to the court about, the allowance of demonstrative evidence and other documents during openings or closings. But I always propose that if the parties want to do such, that they just provide it to the other side 5 days before the start of trial. And it resolved a lot of that to the extent there's any objections. And regarding the issue about it's not a Daubert motion as far as Mr. Lesso's qualifications, it's just the concern. And I do have no objection to the plaintiff responding to the extent the case has kind of changed where Mr. Lesso's opinions about, the statutes and the codes that were applicable at the time of his deposition would be expanded because the building envelope would involve more than building wrap, but now some of those other defendants who are also involved in the building envelope are out, to kind of expand his opinions to other codes to lock correct house wrap in more so than he had at the time of his deposition. So plaintiff, I think, should have a right to respond to that, but that was the concern of why I filed it as a motion in limine and not a Daubert motion to exclude as a testimony in the entirety, because we're not challenging his qualifications as an expert, but just to the extent he tries to modify his opinions at the last minute to broaden the scope of his opinions on our liability and which codes are applicable, because some of the other work that connected to our work, those defendants may no longer be parties in this case.
Okay. So, Ms. Pettigrew, I appreciate you highlighting specific ones that you thought were more substantive, and that it sounds like I'm prepared and it would be reasonable to give the plaintiffs and, well, all the parties really, an opportunity to more fully digest the motions 1, 11, excuse me, 1, 13, 22, and 23. I flagged 11 as the one I mentioned earlier when we were talking about insurance. That, one option may be, again, I question whether, if we are not going to talk about insurance, I question why we would ask jurors if you're associated with a particular insurance company. And in this case, it would probably be like 8 different insurance companies that I would have to qualify them as to. And so one option, to Mr. Capriola's point, as to motion number 11 from correct House Rep, would be to simply ask them if they, once they have some knowledge about the case, to ask them if they think they have any knowledge about the case other than what they've heard in the courtroom, and if they're familiar with any of these parties or this lawsuit, et cetera. And so I suspect that y'all can plan that I will likely do something along those lines, rather than qualifying the jury as to every single one of the, I'm expecting, many insurance companies. Beyond this, as I mentioned to Ms. Pettigrew, most of these motions appear to be sort of standard, these are things that I'm going to do. If somebody invokes the rule of sequestration, I'm going to enforce the rule of sequestration. There's a continuing witness rule regarding what goes back with the jury. These are all pretty standard. And so to that end, I think Ms. Pettigrew's point is a good one, combined with Mr. Capriola's request that the parties have more time to digest the substantive ones. I also expect that because, as all of you have pointed out, the lay of the land has changed, and that may change your client's decision-making process about whether to settle and how big a target is now on each individual defendant, because the bigger targets have gone now, that sort of thing. And so what I think would be helpful is perhaps on the Friday before this trial, which is the 19th, that maybe we just schedule a quick one. It could be as long as an hour if everybody, or if we've still got parties in the case and we still need to work through some of these motions in limine. But to have the parties make an announcement as to who is still standing, who's actually going to trial, and to resolve the final motions in limine. That would also give me an opportunity to address on your exhibits. I believe my standing order has a meet and confer, but if it doesn't, I'm asking you to do so. And that is simply that it's been my experience, especially with a long trial where there's lots of documentary evidence. You guys know this, that if we can avoid the 3-question dance for every single document that has to be offered into evidence, it can literally save a whole day when you're talking about hundreds and hundreds of documents. So instead of having to lay that foundation for every single document, if the parties are all agreeing that 470 of the 500 documents that need to come in are all coming in, then let's treat them that way and get a stipulation on the record regarding that. And then that way we only have to worry about foundations for a certain number of documents. And so we can have that conversation on that Friday. It would probably be in the afternoon, because I think I have a couple of other matters happening in the morning. But what I would do is bring you in on the 19th, like I said, probably around 1 or 2 in the afternoon, to just do a final pretrial. Assuming everybody has not resolved the case, then that would also give us an opportunity to address motions in limine 1, 13, 22, and 23, and any others that the parties might bring to my attention. Does that work for everybody? Okay.
For plaintiff.
Yes, sir.
Okay,
Yes, Your
so
Honor.
Mr. Freehoff will issue a separate notice of hearing on that one. And then I think that addresses most of what we needed to do today. I did have a chance to review the parties' pretrial orders, and it is my intention to go ahead and sign off on those and get those entered. Any other matters that the parties need, questions, et cetera, before we adjourn for today, with the understanding that we will reconvene a week from today?
No,
Judge,
just clarify. Oh, go ahead.
Judge, I do have one question. I represent two parties, and we reached a resolution last night.
Yes, sir.
I guess I would just ask to be excused from any future proceedings, and I think, we're gonna be working through releases and things like that. I don't know what will be done by the time trial starts, but
No,
what would you
and
like to do procedurally what would you like us to do procedurally to be excused?
thank you for asking that question. And especially as others of you might be making those same decisions. I understand, especially in these types of cases, it can take a long time. It can take easily a month, sometimes more, to get everything actually reduced to writing and get all the signatures that you need for an actual dismissal. If you have reached an agreement in principle such that you will not be attending the trial and you believe that the case has been resolved as to your client, file a notice of settlement. I think one other party has already done that at my request. I think it was structurally sound, so that I know that those parties, y'all believe you've resolved the case, but you need some time to do your paperwork, and I can be looking for a dismissal to come at some time a little bit later.
Thank you, Your Honor, and we will certainly do that, but I guess we ask to be excused from any future proceedings.
Yes, but the reason I said that is file your notice. As soon as you file your notice of settlement, then yes, you are excused from future proceedings. But I can tell you that if you don't file your notice of settlement, then Mr. Freehoff is just going to annoy the crap out of you until you do, because otherwise you're still in the case. Yes, Ms.
Thank you,
Pettigrew.
Judge.
Just about the consolidated pretrial order, again, with the changing the parties, the lay of the land is, a little bit confusing to me. But to the extent there may have been a party who listed all their exhibits who are no longer parties now, and we
Yes,
may have had the sentence, any exhibit listed by any other party, so
of
that we
course.
have to keep repeating it, if making sure we don't have to amend the pretrial order to clean that up before the judge, you sign it, Your Honor.
No, I don't expect you to amend your pretrial order to include those things. And that's really why I'm asking you to do a meet and confer, because obviously you're not going to have an exhibit that says exhibit number 72 is all documents offered into evidence by anybody else. No, you're going to have made a decision about which documents you need, and it's going to carry a label. And so that's why I asked for that meet and confer, because it gives you an opportunity. The only reason that would be relevant is if later that document becomes unavailable to you because it's not brought to trial by, say, somebody who's not there. Then you would just point to it and say, look, Judge, I said I was going to need that document, and we'll figure it out from there. But yeah, as far as I'm concerned, there's no need to amend the pretrials. That's why I want to go ahead and get them on file. Anything else? Okay. Well, thank you all very much. I will go ahead and get the pretrial orders on file. I am also going to enter an order indicating that by consent of the parties, the cases will be tried together. And so that we're clear on that. And then we'll also issue a notice of hearing regarding the final pretrial on the 19th. Okay. Have a good weekend, everyone.
Thank you.
Thank you, Your Honor.
Judge.
Thank you.
Thanks, Your Honor.
And for those of you who are here for me and if you could give me like 2 minutes to go get another cup of coffee, I will be right with you and we will get started. Thank you for your patience. Morning. Thank you so much for your patience. I appreciate that.
Yes,
Okay, so Mr. Hendrick, am I correct that you represent me and the plaintiff? Is that correct?
Yes, Your Honor.
Okay. And what happened? Where did the other person that was just here go?
Oh, that was Ms. Pettigrew. She may have just dropped off. I'm sure she'll log back in.
Okay, but she's your client.
Yes, Your Honor.
Okay. So can you tell me, um, so I'm assuming that Mr. Freehoff communicated to you that when we have emergency hearing requests like yours, that what we do is, we tell you, I understand that you're entitled to ask for ex parte relief, but that typically what we prefer is that there's no point in having two hearings, an ex parte one, and then in a week and a half having another full blown. Um, and and so we ask that you provide notice to the other side that the hearing is going to occur. We issue a notice of the hearing, and if, as appears to have occurred here, since even though I told you to come back at an hour later, right, this hearing was actually set and noticed for 9 a.m. So the other side is now an hour and 23 minutes late for this duly noticed hearing. Can you tell me what efforts you made um, well, let me start by saying this. My review of the file indicates that defendant Michael Wilson and defendant Wilson Consulting were served with the complaint about 10 days ago. Um, Actually, let's see. No, it looks like the 25th. So a good bit ago. I haven't done the math with a calendar to figure out if that counts as 5 days and how that would work. But regardless, um, and that Ms. Rooks, and I don't know anything about Naomi Organics, but that Ms. Rooks, at least you have filed a motion to serve by publication based on an inability to have secured service on her. I'm going to ask you about both of those, but given that we have two defendants who have been served, which means I believe Mr. Freehoff can confirm that they would have received notice from the court of this hearing. Can you tell me what efforts you have made to notify any or all of the defendants that this hearing was going to take place?
Yes, Your Honor. So, as you correctly stated, Michael Wilson and his company have both been served. They were served at Mr. Wilson's primary residence. And so we I sent a letter, and I've got it in front of me. It says, "To whom it may concern, Holland and Knight LLP represents plaintiff in the above referenced lawsuit. The purpose of this letter is to provide you with notice that the court has scheduled a hearing on plaintiff's motion for temporary restraining order and injunctive relief on Friday, September 12th, 2025 at 9 a.m. We had the day and time all in bold. And then the letter says a copy of the notice is enclosed herewith for your convenience. And we included a copy of that notice. We sent that to Michael Wilson and to his company. We sent it two different ways, U.S. first class mail and FedEx overnight. And we sent it to the address where Mr. Wilson and his company were served. So we sent 4 different copies of the letter and the notice to that address, to Mr. Wilson, to his company. And then with respect to Ms. Rooks, you are correct. We have been unable to locate her. We have used internet searching. We've used the Georgia Secretary of State. We have used a private investigator that I've previously used to try to nail down an address for her. We sent the exact same letter, and we sent it also U.S. mail and FedEx, and we had found 2 different residences. We sent them to both residences, and then there was a business address on the Secretary of State's website where the principal place of her business it is still listed. When we sent a process server to that address, we were told that he talked to the landlord, and landlord said she had been gone, I believe, for a few months.
Okay.
So
And
we
that's
also,
Naomi Organics is
correct.
the business entity that Ms. Rooks has. Okay.
Yes, Your Honor. So we sent two copy, again, the same letter. We sent it FedEx, we sent it US mail, we sent it to both residences, and we sent it to the principal place of business. And so we have attempted to, and we sent all this out last Friday, by the way. So we tried to make sure, and I made sure that the FedEx was delivered Monday morning. So we took steps to try to ensure that these defendants had notice of today's hearing.
Okay. Thank you very much. I appreciate that. So I'm just wanted to look at one thing very quickly. So so the what I wanted to look at, I'm sorry. What I wanted to look at, Mr. Hendrick, was the service on Wilson and his corporate entity. It looks like service was made on the 25th. It was filed on the 2nd, which is within 5 business days. So that due date for that answer is going to be the 24th of September. So it'll be interesting to see if they file an answer, given that they did not appear today. So why don't we there are two things that we have to deal with today. One of them is the actual request for emergency relief that is being sought on behalf of your client. And what a coincidence. When you said it was Miss Pettigrew, I was like, no, Miss Pettigrew was the lawyer in the other case. Interesting coincidence. But in any event, if you will, I have had a chance to read the complaint. I appreciate very much the time and effort that went into sort of helping the court understand the alleged similarities between the products and the marketing of those products. So I feel like you don't have to reinvent the wheel and start from scratch. But if you can, I always find it helpful to tell me, start with the relief that you want me to give you so that I can ask targeted questions about why and how you would be entitled to that relief based on the facts.
Yes, Your Honor. And the biggest thing that my client is looking for is protection for her company. And I'll specifically talk about those forms of relief. But so you know that this is a company that Ms. Pettigrew started because she saw a space in the market that wasn't really occupied. And she had been selling perfumes, like perfume oils, was how her business started. And one of the things that she noticed was that some of her perfume oils that had a funner, little bit of a racier tone to them really resonated with her customer base. And so, in order to kind of raise the ceiling of her potential revenue, she saw that there was a way to really marriage feminine hygiene products that a lot of times the way they're marketed is pretty sterile with this niche that she had seen with this kind of racier, provocative tone in marrying the feminine hygiene products with sexual wellness products. And her products have been hugely successful. This was not in the complaint, Your Honor, but when I was talking with my client yesterday, she said one of her best-selling products, she has sold over 200,000 units of it since she opened it. So this is a space that she really took over. And up until 24, when Ms. Rooks and her company Naomi Organics attempted kind of a feeble, half-hearted attempt to copy some of her slogans and copy one of her products, there had not really been a true competitor in this space for Miss Pettigrew. And so she was able to expand her business. It wasn't until Mr. Wilson was terminated from her company. And ever since then, the first company popped up within a couple of weeks of Mr. Wilson's termination. And since then, Ms. Pettigrew has been playing this game of whack-a-mole for all of these competing companies. And there is a new company, even since the filing of the complaint. And when I say company, I don't mean a formal legal entity, more like a trade name. We believe that Mr. Wilson and Ms. Rooks are behind it directly or indirectly through one of their business entities, opening up all these new companies. And there is one that, like I said, has opened up since even our complaint has been filed. And their marketing, when I tell you that their marketing, they stopped even trying to be bashful about it, Your Honor. The most recent product that opened an ad, I would like to just share this one screen with you. This has come out since the complaint was filed. And when you look on the left, this is my client's product. This is one of her most popular products. It's called the Big O Tightening Pops. And you compare it to this new entity, Yoni Pops, this new trade name that has come out. You can see it's almost as if they said in ChatGPT, just do the exact same thing, change the names, but it is almost indecipherable between the two. And so what we would like is an injunction that stops all of the defendants, either directly or indirectly, from continuing to market and sell products under any company, entity, or trade name that infringes on my client's trade dress and also trademarks. She has 3 registered trademarks. She has applied for 2 others. And when you look at these products, and Your Honor, I'm trying to be respectful of your time, especially on a Friday. I'm, like I said in an email with your court, I'm happy to put on as much or as little evidence as you would like. But when you are looking at trade dress, when you're looking at the color schemes, when you're looking at the product types, what the product is intended to do, the 2 products I just showed you are intended for the exact same purpose. Okay. And what really started to affect my client's business, because her sales have dropped more than 30% since she started having to play whack-a-mole with these other companies. And a couple of years ago, her top line revenue was about $3.5 million. Okay. So Ms. Pettigrew on her own, by herself, built this wildly successful company. She had gotten it to where her top line revenue was over $3.5 million. She hires Michael Wilson because he promised he could help her scale her company and take it from a 6-figure a month company to a 7-figure a month company. That was his promise. And he said, in order to do it, I've got to do a top to down audit of your company. And that was the first thing he did. And he is the only person that Ms. Pettigrew has ever given access to her confidential, proprietary, and trade secret information. And one of the biggest forms of that trade secret information is her customer list. Okay, my client sells all of her products online, and she can testify that she has spent over $1 million over the year in marketing. And so over the years, through her marketing spends, she has amassed a customer and prospective customer list of over 200,000 individuals. And she is able to use that to send out targeted advertising to reach this audience. And for the first time ever, when Mr. Michael Wilson left, all of a sudden, Ms. Pettigrew began getting these targeted ads for all of these competing products. And she can testify about how, in her experience, which she's amassed a lot of experience, the only way she would have gotten those targeted ads is if a customer list, including her inbox, her identification on these various social media sites, was included in that customer list and uploaded. And she can confirm that her addresses were part of her own customer list database. And so for the first time ever, she's got all of these competing companies that are clearly using her trade dress. They're using her slogans. And here's the other thing, Your Honor. They have also targeted her products that are her best sellers. She sells, over the years, she's sold over 30 products. She currently sells around 20, okay? But her big 4 products or big 5 products, that's where she really makes her money. all these companies that pop up are selling it's like they've stolen all of her greatest hits, her best slogans, her best ads, her color scheme, her top selling products. They're not selling her worst selling product. It's only the ones that have been the most successful. There's all this indicia of insider knowledge that Michael Wilson obtained doing this audit with her company. And Ms. Pettigrew can testify about how when he went in there, he was asking her all these questions to help, under the guise of helping to scale her business, about how she went about creating her slogans, what her overall strategy was, went through he knew which products sold the best. And there's a metric. It's called your revenue to sale, return on ad sales or ad data, so that Ms. Pettigrew was able to calculate and quantify like which ads are resonating, which ones are turning into dollars, and which are not. And over the years, she has had numerous different ad campaigns and marketing campaigns. They have stolen the best of the best across the board. And so what she needs is protection against that. It would be an injunction that says that you are not allowed, either through a business or through some trade name, to offer for sale or sell any products that infringe upon her trademarks or her trade dress. We would need an injunction that prevents them from continued use of her customer list, or continuing to sell to any of the customers that they were only able to come in contact with through her customer list. And Your Honor, we know that we are asking for fairly broad relief against these individuals. They had the opportunity to show up today and respond to this motion, and they have chosen to ignore it. And there is a substantial threat of irreparable harm to my client. The other day, she told me she was scrolling on her Facebook page and she came across an ad and she thought it was hers. It was so identical, and she had to like do a double take and look back at the product because everything about it was almost identical to hers except for a name on it. And so when you're looking, there was the famous Supreme Court quote about I'll know pornography when I see it. And I think trade dress infringement is very similar. When you're looking at these two products, and a lot of these ad campaigns, her Get the Gorilla Grip slogan had been around for years. And now she has seen, and we can show the court if the court would like, 5, 6 different ads that are all utilizing that slogan, which Mr. Wilson knew that was one of her most popular slogans.
Mm-hmm.
And so this is not just coincidence. You know, she has never really had a real competitor in this space. And, you know, within weeks of Mr. Wilson leaving, all these new companies start popping up. And Kitty Cocktails, the first company that opened after Mr. Wilson left, and Ms. Pettigrew saw it. She received one of these direct targeted mailers. She looked at everything. She said, "This is Michael." And so she sends him a cease and desist letter. And he responds, he says, "I have nothing to do with that company, directly, indirectly, nothing to do with it at all." The next day, the company website had been shut down, gone. And then all of a sudden, it's, 4, 5, 6 different trade names that are selling these identical entities. That's not coincidence. It's not. And so my client needs very broad and sweeping relief. This is really drowning out her company. And one of the other aspects is it's also driving up her ad costs, her marketing costs. So this is squeezing her on both ends. And again, Your Honor, if you would like, my client can testify all about why having all these new competing products is increasing her ad spend. It's not just because she's reached the conclusion, oh, I've got to market more. It's because the way these social media sites work, you're actually bidding. And so if you're the only company that's bidding on this particular ad spot, the price is going to be pretty low. And when you target consumers, there's actually an art to it. Okay. if you're McDonald's and you want to send a targeted ad, you could just try to send a targeted ad to people who like fast food, but then it's noise. But what if you could figure out that people who are shopping for UGA football shirts also buy a whole lot of McDonald's, and you know that there is that correlation. And so, through a whole lot of trial and effort, Miss Pettigrew has identified these similar kind of groups, these similar correlations that aren't obvious. That she said, if I target to these groups, I'm getting a very good return on my ad spend. Well, Michael Wilson knows all of those targeting terms. And so now she's having to compete for those ads. And so just for her to do the same amount of ads is costing more because each individual ad has gone up in order for her to win those bids. And so her business is being squeezed on the revenue side, on the cost side. Her trade dress is being infringed. She is being drowned out by all of this other noise, and she needs that to stop. And so that is the relief we're seeking, Your Honor.
Okay. Mr. Hendrick, I have a few questions, and mostly they're procedural rather than substantive. As I said, I really appreciate the detail that was put into the initial pleading. Obviously, it's one-sided. I don't know what the other side would say if they were here to defend themselves, but I'm comfortable in saying that they were given an opportunity to do so and have elected not to. And so I'm happy for now to accept at face value what has been represented in the complaint. But again, it's quite detailed, and it's good at helping the court understand what your client's particular concerns are. What I'm not sure I understand is how, other than sending out cease and desists left and right to every entity, how are you going to enforce even a temporary injunction that you're asking the court to provide?
Well, and Your Honor, one way that's an excellent question. And if the order was fashioned that they had to respond and certify within a certain period of time, that they are not involved in a new company. So let's say, because like I said, there have been 5 new trade names that have been selling very similar products. But if your order provided that, let's say that Ms. Pettigrew next week has another ad and it is just like we have been seeing, but again, under a new name, that she can provide notice to them in the form of almost an interrogatory that says, or a request for admission, admit or deny or tell any and all involvement you may have had with this product, and they have a certain period of time to affirmatively state that they had nothing to do with that product or the selling of it, that the customer list was not used to market it, something along those lines. And then only in those instances where they either refused to answer or admitted that they, were somehow involved, would we need to involve the court again?
Okay. So, based on what I have seen, I am satisfied that your client has met the standard to receive a temporary injunction. Now, the intention of a hearing like this is to be able to enter a more longstanding injunction, because I would have an opportunity to hear from the other side. But again, the other side has elected not to be here. And so I think even though I'm authorized to enter a more longstanding injunction, I think what I'm going to do is enter a slightly more temporary one. I am going to grant the injunctive relief that you seek in terms of, prohibiting the defendants in this case from directly or indirectly, personally or through another entity or trade name, from marketing and selling these, products competing with the, products that are being sold by Miss Pettigrew's company. The reason I was looking at the deadline for, so typically a temporary restraining order like this, the deadline, the longest time that the court would impose it would be about 30 days. And then at some point would have an opportunity to hear from the other side and then could determine whether or not it needed to remain a permanent um, restriction. And so the reason I was looking at the calendar was my calculation based on an August 25th service date on Mr. Wilson is that Mr. Wilson would have until the 24th of September to file a timely answer and would be unable to open default as a matter of right after October the 8th or 9th. And so what I'm going to do is reset this matter for a hearing on the 10th, which if I enter an order today, that'll be less than 30 days, which is typically the target. And then by then we will know if at a minimum, Mr. Wilson and his corporate entity are going to actually file an answer. If he doesn't, then the nature of the relief that you're seeking would be made a final judgment of the court. And you would at least have that to work with. In terms of seeking, contempt or, damages or whatever it is you might do with such a judgment. So what I'm going to do, Mr. Freehoff is on the call. I'm going to ask him to set a hearing for the 10th of October. As I said, by then we will know if Mr. Wilson is going to be in default or not. And we will also have an idea of any further efforts to secure service on Miss Rooks. Now, obviously, serving her corporate entity is going to be a little easier because you can substitute it through the Secretary of State. Finding her, different matter altogether. I do see. So let me back up for a moment. Can you please provide me, Mr. Hendrick, with a proposed temporary restraining order, temporary injunction that provides that language that you're talking about, that prohibits these defendants from directly or indirectly, personally or through third parties, from marketing and selling products that are competitive to the products that Ms. Pettigrew's company sells or utilizing her customer lists, et cetera. You can make it as broad as you want, as long as you feel like it's supported by the evidence or the allegations that you've made in your complaint, because that's what we're working with. Those are the facts that we're working with now, Mr. Hendrick. As I said, it will be in effect until the 12th of October, if I enter it today. And even if you can't get it to me until Monday, it would still be effective as of today based on my verbal ruling. And we would not per-tunk it back to today anyway. So send me that, number one. Email that to Mr. Freehoff in Word format. Second of all, I know that you have a motion for service by publication that was filed regarding Ms. Rooks. And an affidavit of diligent search in support of that motion for publication. I wanted to tell you that the additional information that you provided in the affidavit of diligent search. When I first saw the motion for service by publication, I was like, wow, that's really fast. But then I do appreciate you providing me with a great deal of information in the affidavit of diligent search in terms of efforts to actually locate Ms. Rooks. So again, not telling you how to do your job, but I assume that I will see something regarding an effort to serve through the Secretary of State on Naomi. But for now, I do believe you have satisfied the burden to serve Ms. Rooks by publication. And so I will grant that. I will grant that motion. If you could please send me a proposed order allowing service by publication, we'll get that on file as soon as possible. And then we will wait and see if Mr. Wilson appears for the subsequent hearing that we're going to notice for October the 10th or not. And then, of course, wait to see if we hear from Ms. Rooks or her company through efforts at service. Is there anything else? One thing I would ask you to please do is include in your order, the proposed order that you're going to send me, what we talked about at the beginning, which was that that it was not this court's intention to conduct this hearing as an ex parte hearing, that the court instructed the plaintiff to make all reasonable efforts to notify the defendants, including two who had been served at the time that this was noticed, of the hearing. And just a brief sentence or two, you don't need to attach exhibits or anything, but just a brief sentence or two outlining that the plaintiff made a showing to the court of efforts made to notify the defendants of this hearing. And so the hearing did go forward on an ex parte basis, and that because of that, the court is going to treat it as a temporary order, and it will be in effect until, as I said, the 12th of October. No, hang on.
You said 12th.
Yeah, I did say 12th, but I think the 12th is a Sunday, and I meant to say the 13th.
Okay.
So it will be in effect until the 13th of October, and we'll have a hearing on the 10th of October to determine whether you get final judgment or whether it continues or whether I vacate it because the parties actually appear. Mr. Freehoff, did you have something?
No, I didn't. I just know that you wanted to have a discussion with me at the end of this hearing, so I thought I would make myself visible. I do want to say that I believe Mr. Hendricks may have already sent me a proposed order on the motion for service by publication.
Okay.
I didn't want him to worry that that had not come through.
Okay. Well, if we've already got an order on the service by publication, then obviously you don't need to resend that. I just need the order on the temporary restraining order. And as I said, particularly to include that brief additional information about the fact that it was not this court's intention to conduct this hearing ex parte, that reasonable good faith efforts were made to notify them, and that given that they were served at those same addresses, the court has reason to believe that they chose, at least Mr. Wilson and his company, chose not to appear. And then we'll make sure whatever language we want is in there, and then we will get that on file for you as quickly as possible. Okay?
Okay. And
anything else that you need from me, Mr. Hendrick?
The October 10th hearing, that'll also be a Zoom hearing?
It will, yes, sir.
Good. Great. Perfect. Okay. That's everything I need, Your Honor.
Thank you so much. Have a good day.
Thank you. You too.
Thank you. Bye-bye. Have a good weekend.
Did you want me to stay on Zoom or did you want to talk on the phone?
No, just stay on Zoom since we're both here, but can you unlive it? There's no reason for us to live stream to YouTube our scheduling conference.